competency level? Does it separate those who've achieved from those who've not achieved? If it doesn't, if it's not a valid discrimination, then it will be struck down. Either a legislature won't approve it, or a court, if they're considering approval, or a court will overturn it. Validity is the toughest test. If you get over the threshold of professional necessity, validity is the toughest test for any credentialing program, whether it's academic institution accreditation or professional certification or even product certification. The reason is that not a lot is known about validation of a testing process or a criteria process. Traditionally, as is no doubt the case in your own program presently, a series of experience requirements, education requirements, and often a written or oral examination requirement are accumulated, and the theory that psychometricians will tell you is that with all that in the background, experience, education, and completion of an examination, there is a tendency for this individual to more likely be minimally competent than not minimally competent. Unless experts can say that about your program, whether it's a state licensing program or a voluntary professional certification program, courts are going to overturn it, and they have overturned these programs for lack of validity. If the requirements that you impose are not, reasonable ones. Courts, when they look at a professional credentialing program, look at whether the program has reasonable criteria and whether it has fair procedures. Under reasonable criteria, they want to know that they're not vague criteria. Is this person a good professional public relations consultant? That's why personal and professional recommendations and criteria sometimes get overturned when courts review these things, because they're an obvious opportunity for blackballing rather than for objective measurement and evaluation of professional competence. They want to know that the criteria you establish for credentialing are related to the profession being examined and for which some certification or license is being conferred. They want to know that they're not excessively strict. The Federal Trade Commission got close to bringing a case against a credentialing organization, a private professional credentialing organization of orthotists and prosthetists. Who knows what they do? Artificial limb and brace boys. They had criteria which almost no one could meet, and the result was that FTC thought about and got very close to issuing a complaint, even issued a draft complaint to that organization, but lo and behold, Reagan was elected and the case was dropped. The reasonable criteria would also take into consideration whether they're non-discriminatory. Increasingly, for example, the Educational Testing Service, which does the college board exams but does a heck of a lot of private administration of examinations to professional organizations, has found that it has to offer its tests in multilingual format, because otherwise courts will say it's not fair if you don't offer these things in Spanish. Non-discriminatory. Also, courts are creatures of procedure, and it's a heck of a lot easier for a court to look at a decision, a self-regulation decision by a profession, and determine that procedures weren't followed, rather than going in there and deciding that the criteria, the professional criteria, weren't the right ones, because judges are lawyers, not public relations professionals, or not professional golfers, as in the case of Jean Blaylock, who was seen by her colleagues about 10 years ago to be kicking a ball toward the hole in a tournament. She was summoned to the clubhouse and excluded summarily from the Professional Association of Ladies Golfers, and thereby prohibited from participating in lucrative tournaments for the next 1 year. She sued, and a court said, look, I don't know if she kicked the ball or not, but I do know you didn't give her a chance. You didn't give her in writing what the charges were. You didn't let her interrogate the folks who said they saw her kick the ball, and you didn't give her any appeal right to some objective organization. That is minimally required, the court said. We don't need for the Ladies Professional Golf Association to follow the strict procedures that we would as a court, but there are some basic elements that you've got to that you've got to follow. You've got to be. Some courts have said that a professional self-regulation program is best conducted in an as autonomous from the professional society. The theory here is that the professional society is there to promote the profession, and how can it, doesn't it have mixed motives and potential conflicts when it's engaged in a program whose primary objective should be to protect the public? And autonomy is a vague and not yet really, not a requirement, but a desirable goal for a self-regulation effort such as credentialing, whether by, as in certification. Objectivity of the organization, which really relates to autonomy, and notice and appeal, which are minimal due process requirements that courts have universally imposed upon private self-regulation bodies such as credentialing organizations. The conclusion, it seems to me, from analyzing and advising over the years, and in the case of the Consumer Patient Radiation Health and Safety Act, having written it, in the case of the orthotist prosthetists, having defended them, and in the case of the ophthalmologists having gotten FTC to prove their code of ethics, it seems to me that if a self-regulation effort, as a voluntary one, a certification program by PRSA or some adjunct of PRSA, is really committed to the public interest first and foremost, it will likely succeed. If it engages in a licensing effort to get states to pass laws that would license either the title or the practice of public relations, if it can really substantiate that it's in the public interest to do that, not in the profession's interest to do that necessarily, then it will make a case, and in the licensing situation, it will probably induce legislatures to pass licensing for for public relations, and in the voluntary situation, it will probably induce hordes of public relations people who are not now credentialed by your organization to seek to become credentialed. Several years ago in Sports Illustrated magazine, there was a profile of the late coach Amos Alonzo Stagg, I guess after Bryant and Hallis, the third winningest coach in football. His wife was interviewed, and his wife described how in his retirement years, the coach here in Chicago would mow a little plot of grass in front of his modest house in the city of Chicago every morning. His wife said he mowed it to death. And she described how one day a neighbor was walking by in the morning and said, "Coach Stagg, you're nuts. You're never going to grow grass here. Don't you know that the boys come by every afternoon, play football, and beat down your lawn?" And the coach thought a minute, looked back at the neighbor, and said, "Don't you know? I'm not growing grass, I'm growing boys." In the same way, it seems to me that if this organization, on behalf of the tens of thousands of folks it represents, decides that it's going to engage in credentialing of professionals or promote credentialing of professionals in the public interest for the benefit of those who use or see the results of the work of you professionals and your colleagues, you are likely to succeed, whether through licensing or through voluntary certification. If instead the chief aim is to help public relations and help public relations professionals, I promise doom. Thank you.
Run away, Jerry.
Of professions. The nurses have 153 different credentialing organizations. If you count the 50 state boards, the myriad of specialty nursing voluntary certification organizations and those who accredit state education programs in nursing, there are 153 different ones, and virtually, and very few of them are transferable from one state to the next. Indeed, there isn't even any organization in nursing that keeps track of what professionals are what and who holds what. Lawyers have fought for years to have reciprocity, but through feather bedding, if I'm licensed in Illinois and in the District of Columbia. If I go to Iowa and want to argue a case, my client has to hire an Iowa attorney to appear and move me into the courtroom for the purposes of arguing that one case. Clear feather bedding, clear monopolistic activity, but legal because it's done at the state level through state licensing boards. I think that mobility of state licensed professionals is a serious problem, and no profession has very successfully dealt with it yet.
Can a professional organization or any organization require membership for credentialing?
There isn't a clear-cut case in which a court has said you can't tie them. Many professional societies have slowly divorced professional credentialing from the activities of the society. They may retain some extensive relationships, They may have the power to appoint some of the board members on the new credentialing board, or they may otherwise help fund through grants, since in its early years, certification programs often lose money. But the theory behind the autonomy that I mentioned earlier is that a certification board exists for the public interest first. If there are advantages to the profession, great. But the first aim has got to be able to tell the public that these folks have achieved and these folks haven't, or these folks are minimally competent and these folks aren't. That is simply inconsistent philosophically and leads to inevitable conflicts of interest between the main aims of a professional society, which exists first and foremost to advance the profession. So, many organizations have divorced their credentialing or other self-regulation body from the professional society itself, spun it off into a separate but related organization. In fact, there isn't, I can't point to a strict legal requirement or even a single case which says you must do that. I do know that in the healthcare area, the National Commission of Health Certifying Agencies, which is an umbrella organization for those boards that certify health professions in specialty areas after they've already achieved licensing, I do know that they require legal autonomy of certification boards. That means separate incorporation. The theory is that certification board is looking out for the public interest, professional society is looking out first and foremost for the profession's interest, and the aims are going to get confused if you tie them up forever.
You will hear a brief presentation later on a proposal authored by David Brown, a prominent government practitioner, for a form of autonomy to that extent. Other questions of, yes, Frank?
Would you comment a bit more about acceptable criteria for academic institutions and curriculum accreditation?
Most groups that certify are voluntary professional certification that operate those programs are somehow related to an accreditation arm. The fact is that professional societies, while they have rather readily spun off into independent, semi-independent organizations, let's say substantively autonomous organizations, the credentialing function, the granting or denial of a certificate and title, the requirement, the formulation of the requirements for that granting or denial, whether by experience or education or examination. Very few professional societies have spun off the accreditation arm. The best guess, and it's only a guess, is that accreditation is very important, especially for continuing education programs that make a lot of money for professional societies, and they've been very reluctant to say goodbye to that accreditation of continuing education, which brings in money to the organization. That's only a guess. The fact is that there is no reason why accreditation shouldn't be conducted just the way I'm suggesting that certification is best conducted. That is substantively autonomous. I don't really care if it's a committee of a professional society, as long as the professional society has given them substantive decision-making autonomy and has told them to go out and accredit programs or schools that are best, not that are best for the profession, that are just best. And accreditation really ought to follow the same rules. It is credentialing, just like professional certification is. The only case that exists, the big case on academic accreditation, involved a school called Marjorie Webster in the District of Columbia about 30 years ago, and a federal appellate court said that a credentialing, an accrediting body, the Middle Eastern States higher education body, could exclude Marjorie Webster from accreditation because it was privately owned rather than a nonprofit organization. The appellate court upheld that as a reasonable requirement. There's almost no chance that it would be upheld today.
Let's see, Dwayne, you're our treasurer. We lose money, don't we, on accreditation? We certainly don't make it. Well, we can feel good about that.
Most
anyway.
organizations lose money on accreditation and make it on certification.
Yeah, right. Well, there's the way to go. Isabel?
Yes.
That would be anybody who would pass the exam.
This is part
Tying,
of
it's related to the question of the gentleman up there, tying professional society membership to professional certification by an autonomous organization in the public interest is simply inconsistent.
Is it possible to insist that acceptance of code of ethics is
Yes. And there